Okay, well, I think that's us ready to start this session. Thank you all for joining us. My name is Jim Fitzpatrick. I'm with Open Democracy, and I've recently joined, and my kind of two key areas are SLAPPs and dirty money, and obviously those two things cross over quite a bit. Previously, I was with the BBC, business, politics, and investigative current affairs over the last 20 odd years in different roles. So looking forward to this discussion where we look at what's happening in Scotland and in Northern Ireland. With me on the panel here, we have Rosalind McInnes, who's in charge of all the legal affairs at BBC Scotland, and Nick Williams from Index, who also has a lot of experience in Scotland as well. And joining us down the line, we have Sam McBride from the Belfast Telegraph, and hopefully soon Mike Nesbitt, MLA. So if I could ask Sam maybe online to tell us about his experience as a journalist at the coalface in Northern Ireland and what it means there from a legal point of view. Sam.
Good afternoon from Belfast. And Jim, can I just double check that you're able to hear me clearly okay?
We can hear you, Sam, yep.
Fantastic. I've worked here as a journalist for about 16 years, mostly in newspapers and mostly covering politics.
A little bit off mic. Sam, sorry, can you just check your sound there again? Just in the room, can I just check? If people nod, if you can hear me, is it too weak? Just a little bit low on the sound. Just give us a few lines there, Sam, and if it is weak, we'll jump to somebody else and come back to you.
Sure. So I've worked here as a journalist for about 16 years, mostly in newspapers, and I've mostly been covering politics. And in that time, the use of often spurious legal threats to scare off investigative journalism has been a constant, often in relation to senior political figures in the DUP and Sinn Féin. Those are Northern Ireland's two dominant political parties. And unfortunately, this, I think, is a very significant issue, which is now stopping what are awkward questions being asked in some questions, but very legitimate questions in the public interest. Can I just clarify if you're able to hear me okay, Jim?
I think it's still a little bit weak. What I'd ask you to do perhaps is bring your computer a little bit closer to you if you can. It might make a difference in terms of picking up the sound.
Sure. Let me try this. I have been in a position where asking awkward questions of some of these politicians has led to so many solicitors' letters that I could paper my walls with them, unfortunately. These are not situations often where there are legitimate reasons to be resorting to the law. There are obviously very good reasons why we have libel laws. There are people who abuse those laws and who are rightly held to account for that. But these are often around things which these people know to be true, know to be accurate, know to be in the public interest, but they do not want the public, their voters, the people who put them where they are, to be able to find out what they are doing. And for a regional newspaper industry, and this is common to the rest of the UK and Ireland, which has been shrinking massively over the time that I have been a journalist, over the last 15 or 16 years, even defending some of these ludicrous claims can cost a fortune. It doesn't always matter whether you win. It doesn't matter whether the claim actually doesn't ever end up in court. It can bog you down in very expensive litigation for a very long period of time. One case in which I was involved cost about £200,000 in legal fees. That was a case which didn't ever even enter a courtroom for trial. That sum, for context, would have paid the salaries of the entire reporting team at that newspaper for a year. That's the sort of really difficult decision that an editor faces. Does he spend that money on reporters, or does he spend that money on standing over a single case which he knows is right, but which may cost so much that he's not able to keep doing his job as an editor, getting that paper out if it goes badly wrong for that paper? And when the libel laws were reformed in England and Wales almost a decade ago, DUP politicians in Northern Ireland secretly, without any announcement, without any consultation with their other Stormont executive partners in government. They blocked Northern Ireland from that process. They've never fully explained why they did that. And a year ago, I gave evidence in support of Mike Nesbitt's bill, a private member's bill to seek to extend those reforms to Northern Ireland belatedly. That happily largely got through. Some of it didn't get through because the DUP and Sinn Féin united. One of the few things they were able to unite on was in blocking an aspect of that. But when I gave evidence in support of libel reform to the Northern Ireland Assembly's Finance Committee, I was able to speak under privilege. I was able to speak without any fear of even spurious attempts to try to impede my freedom of speech there. And I was able to speak about some of the individuals, name some of the politicians involved in these threats. But even though we've now got some of those defamation reforms through in Northern Ireland, thanks to this new legislation, I do not feel that freedom as I speak here today. I cannot say here what I was able to say there. And there is a really insidious secrecy which surrounds many of these cases. They're not known about beyond a handful of people in Northern Ireland, people either in journalism or in politics or in law. And it's very difficult for people in my profession to speak freely about these. Generally, as journalists, we are bound by our contracts to confidentiality around these matters. Lawyers obviously cannot speak about their clients without their permission. And so much of this is never seen. It never enters a courtroom. It is never reported in the newspapers or on the broadcast media. But it actually explains a lot of what isn't reported in our media in Northern Ireland. And when about 3 years ago, I published a book as an individual, a book called Burned, which examined and exposed the cash for ash scandal at Stormont, telling the story of the Renewable Heat Incentive, or RHI. That was a massive scandal. It was a scandal which brought down our entire system of government. It led to a massive public inquiry into how Northern Ireland was governed, essentially. But that put me in a very different position, because normally as a journalist, the worst that can happen in this area is that a legal threat leads to the story being retracted. It leads to a very embarrassing clarification or correction. It leads to a payout to the individual who has made the claim, leads to very big legal bills. In an extreme case, I suppose my employer might go bankrupt if they get this badly wrong in a dreadful libel, but it would stop there. That would be it. My employer is a newspaper. They indemnify me personally against anyone who tries to sue me on a personal basis based on what I've written in my employment. But when it came to my book, the reverse was the case. I signed a contract in which I indemnified the publisher. I guaranteed that there would be no libels in that text. And even though it was possible that my publisher would have stood behind me if there had been a claim, and I certainly hope they would have done so, there was no legal guarantee for the publisher to do so. In fact, the reverse was true. I had legally guaranteed that I would foot any bill that arose from anything that was judged to be defamatory. Several months before that book was published, I put several questions to 5 senior DUP figures: the then leader of the party, Arlene Foster, the chief executive, Timothy Johnston, former special advisor, Andrew Crawford, former First Minister, Peter Robinson, and former Minister, Mervyn Storey. Some of those people were asked about incredibly serious allegations. Other of those individuals were asked about matters that were frankly almost trivial. They were important to me as a journalist seeking to accurately record what had happened, what the date was that a certain conversation took place, or where they were on a certain day. But they were actually not something which, even at the most extreme interpretation of the libel laws, could in any way have been judged defamatory. And yet I got an immediate response from a solicitor for those individuals who said, quote, "In the event that publication of inaccurate and defamatory material occurs, our clients are fully prepared to issue appropriate legal proceedings, which will, of course, include the publishing house as a co-defendant. Please take careful note of the position in this regard and notify the publishing house accordingly," unquote. I was in a situation in which all of my earthly assets would have been grossly inadequate to cover even one of those individuals taking a serious libel action in this situation. There was here the possibility of 5 separate legal actions being taken if they had followed through in their threats. Some of those threats I knew to be risible. They did not have any basis in law whatsoever, and it was simply an attempt to put pressure on me and on my publisher. However, for some of them, I was not to know what a court was going to say. I was not to know what a jury was going to say about that. There have been perverse outcomes in libel actions before in Northern Ireland. And so it was a situation where if I lost, I was bankrupt. And even if I won, I was maybe bankrupt. That meant that I had to have a pretty uncomfortable conversation with my wife. My deciding to press ahead and publish the book in an unamended form was going to not only have implications for me, but for her, for our young family, for the house that we live in. That is not a situation that an investigative journalist doing due diligence by asking people about whom they're writing reasonable questions in the public interest about a massive scandal which saw taxpayers lose a massive sum of money in Northern Ireland, and in fact was more than that. It was about taxpayers elsewhere in the UK losing a huge sum of money in Northern Ireland. There was no justification for that, and yet that is routine in my experience. Certain individuals behave in this way because they have done so for a very long period of time. I should add that there are lots of politicians who do not behave like this in the DUP and Sinn Féin and other parties. And I should also add that several of my journalistic colleagues in Northern Ireland who report on the paramilitary underworld here have received far worse threats. Police warnings about threats to their lives. They have the very difficult requirement to fortify their homes, to vary their routines because there is a serious threat to their safety. So in many ways, I'm privileged that I'm reporting on people who mostly resort to more genteel forms of, let's say, bad behavior. But this is something which particularly young journalists coming into the industry should not have to face. It's wrong. It is in many cases, I think, an abuse of what our laws there to protect people from bad behavior. And the final thing I would say is that SLAPPs are often taken as an acronym for strategic lawsuits. And in this instance, and in most of the instances in which I have been involved, there actually has never been a lawsuit. It's never got to that stage. But the effect is such that it would lead reasonable people in many instances to give up writing about this, to go and write about something else, go and find something else which will fill a column, which will fill a book, which will not lead to these very difficult situations where they're having to consider their personal finances, even if the public really need to know what it is that's being suppressed there. Thank you.
Thanks very much, Sam. And I think a lot of people will be very interested, intrigued, and shocked perhaps at the idea that you had to indemnify your publisher. Such are things in Northern Ireland. But we'll come back perhaps to that issue and others. Let's jump to Scotland. And Rosalind, you can tell me and tell us what it's like at the coalface there for a bigger organisation, the BBC, and what it is that you've been dealing with over the last number of years.
Well, I mean, personally, I have to say there's nothing like hearing a journalist talk about the experience of being in the thick of this to make me feel very unsorry for myself. But nonetheless, there's a lot that's been said this morning to which I can relate. I have an open plan office, so I've got no walls to paper, but if I did, I could certainly paper them with the same old stuff from Shillings and Harbottle and Lewis and the usual suspects, with the usual playing to the gallery for their own clients, telling the journalists what their own codes are at length, citing the same cases that we may be taken to be being across, being accused of sensationalising things which, if I were paid good money for, I couldn't sensationalise, like salmon stock farming and ferry procurement, criticism of the integrity of my colleagues by people whose clients I would not trust further than I could throw them, and so on. However, the BBC is at the moment, thank God, a reasonably well-resourced organisation, and I'm obviously not intimidated by all the legal jargon that floats about, and by people who have or purport to have the fond delusion that if they put not for publication at the top, that they will make my investigative journalism colleague somebody who's bound to keep their secret, which a proposition so bizarre that there is no case law for it, presumably because nobody was ever desperate enough to advance it in a court. However, all of this stuff, it happens. And as I say, as a lawyer, I can take it on the chin. It's just the game that we all play, but it's not a game if you're a journalist, and it's not a game if you're a source or a whistleblower. And at the end of the day, journalism doesn't exist to keep media lawyers in a job. It exists to serve the public interests of all of us. So even though I say this absolutely without a trace of self-pity, it's nonetheless the case that even if you're an experienced media lawyer who is a flat cost in a responsible and reasonably well-resourced journalistic investigative journalism outfit, it still affects how you go about your business. You know, I mean, as a Scot, I have been bitten by a lot of midges in my life, and none of them have killed me, and I'm not afraid of midges. But at the end of the day, there are beautiful places where I would sooner not picnic, and that is kind of where we are with investigative journalism. There's some things where the intimidation is too strong a word, but nonetheless things don't get done. But specifically in the Scottish context, when Nick and I were doing our job of getting a Scots law defamation law reformed, essentially to bring it into line with where England and Wales had been since 2013. That was the work of 11 years, really, or more. I mean, in 2012, I wrote to Kenny McCaskill, who was the Justice Secretary, saying, can we have a bit of this nice, shiny Defamation Act 2013? And got an answer back from his office saying, no, there's no need to reform Scottish defamation law. I think it's probably fair to say there'd be no clamour to reform it. You have to look again at the demographics of Scotland, where you have something which, relative to the UK as a whole, or to Great Britain as an island at any rate, is quite a large part of the landmass. So the Highlands and Islands alone, same size as Belgium. But in reality, all the Scots in the country wouldn't make up a quarter of the metropolitan London population. So you have a very small pool of people. You don't have a specialised media bar either in the solicitors branch of the profession. There are no Howard Kennedys, there are no Reynolds Porter Chamberlains. And that is reflected in the regulatory organisations, the Law Society of Scotland, the Faculty of Advocates. They're riven because their clients, their members' interests are riven. And it's easy to sit in this room and think, well, we're all doing God's work. But as far as the media lawyers in Scotland are concerned, they're doing a job, and they have to act for both sides of this argument. So that makes it difficult to have a focus which is driven by informed legal opinion in favour of freedom of expression and investigative journalism, and that's not going to change. That is a question of demographics, and that's just not going to change. So we're not going to have that kind of MLA pressure point of informed opinion. It's just not going to happen. We don't have that. We also have a fundamentally different legal system, and although I very much wanted, as a media defence practitioner, to have the 2013 Act, I wanted the single publication rule, I wanted the serious harm test, I wanted a codification of public interest journalism and a codification of the Derbyshire County Council principle. All of that was honey to the bee for me. But Scots law is not only a different legal system, it's not even a common law system, properly speaking. It's a mixed jurisdiction. And you wouldn't have to be politically nationalist to say, well, you know, different legal systems can naturally arrive at different results, and that's fair enough. We don't all have to read off the Westminster hymn sheet. So you've got to get around or make a persuasive argument for not why the law has to catch up with somebody else's legal system, but why the law needs to move in a particular direction. And you need the right cases, and you need the right people to do that. So I'm not pessimistic at all about the future of Scottish defamation law. There are elements of being a small jurisdiction which make it easier, if you're sufficiently well resourced, to hold your ground. And certainly in the centenary year of the BBC, I know that Lord Reith would not wish me to write under a BBC letterhead, fuck off to anybody, because we would never end a sentence with a preposition. But I am actually in a reasonably good position to say a lot of the time I have authority to receive a writ which is basically Scott's lawyer for fuck off. So,
Mhm.
so if you can do that in a small jurisdiction, if people know you're going to stand your ground, you have to do it less often. But that doesn't mean it's not attritional. And particularly it's attritional in people you probably will only be able partially to protect. You can pick up the legal costs of the people you're acting for. You can give them support. You can give them a shoulder to cry on and informed advice and all the rest of it. But you cannot, for example, stop a whistleblower from being struck off as a teacher or a midwife or many of the other situations that we've seen with people who are whistleblowers. And you certainly can't protect people adequately against death threats, though we can and do protect people against physical intimidation. So it's a problem. It continues to be a problem, however relatively rosy and relatively experienced you are.
Thanks very much, Rosamund. Yeah, I mean, as somebody who worked for the BBC in Northern Ireland, actually, until quite recently, and dealt with BBC Legal, I know what a big job they do. And in fact, David Atfield, who is head of legal in London there, gave evidence to the committee that Sam was talking about there, where he talked about his experience in Northern Ireland and what a disproportionate amount of his time was taken up dealing with cases in Northern Ireland. Not just because of people like me making this life hard, but because of the law there and the context and how much more difficult it was to work there. So that's been something that you've addressed in Scotland. Nick, tell us about the campaign there and how you've reformed things and where you think things still need to go.
So I mean, so I was trying to figure out what the Reithian way of saying "fuck off" is. Off is that you shall fuck or something. As Ros was pointing out, so Scots law was reformed in eventually 2021 the law came through, and this was after we took, I think, two technical, relatively technical clauses from the 2013 reform, but defamation law in Scotland hadn't really changed since '96. And I always think of it like Mark Zuckerberg was 12 years old when Scots law was last reformed. So surprise, surprise, it did nothing for social media users, blogs, online publication. It was incredibly out of date. But we seemed for a long time to be totally satisfied with that. I mean, McCaskill, I think his phrase was that it was sufficiently robust.
Yeah.
Or something when the clamour started to come. And you'll notice we're talking about defamation because SLAPPs as a political and legal proposition in Scotland is even further than England. Roger Mullins, a former SNP MS, I'm looking at Susan, put forward a petition to look at a Scottish sort of anti-SLAPP mechanism. It caused a little bit of hubbub in the people who were already talking about it, but it's not where it is. And obviously there is a worry that the infancy of the Defamation and Malicious Publication Acts will further push that back, because they will say, well, we don't need it because we've just passed this. So a lot of them are talking about SLAPPs in Scotland. A lot of it will be framed around defamation. So there was a long campaign for a number of years, led by a number of organisations: Scottish Pen, BBC Scotland, Open Rights Group, Humanist Society, the NUJ, to push forward with reform. And it was amazing how, so much of it was the open door. The Scottish Law Commission had flagged this as a position needing of reform, but the systems itself were really slow. I always remember my favourite moment of the reform campaign was when the Faculty of Advocates submitted evidence to either the Commission or Parliament, I can't remember, basically saying that the law didn't need to change because it was an economic driver to Scotland that more money was coming into solicitors and advocates in Scotland. I mean, this idea that increased costs to defend defamation was actually an economic driver for resisting reform is remarkable. I mean, we got a good op-ed about it to talk about and say, well, this is not, laws aren't there to drive up sort of money for the exchequer. But under the surface, there have been a number of cases that if the system looked hard enough, that should have rang alarm bells. Cases that I would look back at now and say, at least have the conversation as to whether they would satisfy SLAPPs. For me, the legal threats made against National Collective is a really glaring one. So people don't know, National Collective is a very small independent blog publishing around the time of the first, the only indie ref in 2014, and they were reporting on some of the money that was being donated to both campaigns, and they were writing about Ian Taylor, who is the CEO of Vitol, an oil company, who had donated to the Better Together campaign. And they were reporting based on publicly accessible reporting carried out by other journalists in generally national newspapers from across the UK, not just Scotland. But they're a very small team. But they had sort of the reporting seemed robust. They received a letter after publishing their piece from Vitol threatening defamation action. And so because they were very tiny, and this goes back to Martin's point earlier about what happens when it is an independent or small or a blogger. Their only recourse at that stage was to pull down their entire website because they just couldn't risk it. You've got one of the biggest oil companies threatening you. It was only after getting pro bono legal support from Amar Anwar that they were able to sort of understand their position and push back a little bit. But at the same time, I think the Herald, I think the Guardian, I think a number of other publications had reported on this. They may have received legal letters, but oftentimes they wouldn't have, but they knew that they had a strong basis to defend themselves. National Collective weren't in that position to be able to do so because they were, I think, 2 or 3 independent research writers and journalists. And that case just was there, but there hadn't been that sort of snowball. Some of the bigger cases, the recent threats against Andy Whiteman, a former member of Scottish Parliament, was eye-watering. He was being threatened for £750,000. Scotland doesn't have the legacy that London does for 6-figure, 7-figure damage claims, but that would have been Sheridan's 200,000, I think,
200,000.
and that's the record at the moment for damages in Scotland. So this would have been nearly 4 times that, and it was about content Whiteman had written as an academic prior to entering Scottish Parliament, and then they waited. And basically, and it felt like, I can't say that this is a conscious decision, but legal threats didn't come until he was in Parliament, and he was a lot more high profile. And it was a huge case, and it ties into this growing dynamic of defenders having to crowdsource just because of the inequality of arms. Mercifully for everyone, most notably Andy, the case, he was successful in defending the case, but it was long, it was tortuous, it was really quite chilling because this is someone in Parliament, and this was a show to say, we don't care where you are, we can still threaten you. So, and I just want to say a few quick things about some of the conversations we were having as the bill was going through Parliament, because Scotland coming later to defamation reform, it did offer us the ability of look what worked in 2013 and what didn't work in 2013. And so one of the things that didn't work, for example, in 2013 is, well, I don't think it works, is the protection for web internet intermediaries. It becomes almost like a checklist that platforms go through, but they don't actually do the steps to protect what's being hosted because they themselves are liable. So they'll do what's quick and easy and take down an article or something. This came from Northern Ireland, actually. Andrew Scott, who had looked at instead defining author, editor, and publisher as a better way of looking at where the responsibility and therefore where the liability sits. And the Scottish Legal Commission really liked that, and that was incorporated into the final bill. But a number of other things that we were trying to push for which didn't come in, because as Ross was saying, a lot of it's harmonising into 2013, but there are some interesting elements. So a statutory definition of defamation, Derbyshire principle, which prevents public bodies from bringing legal action, is now actually in the statute book. It's not dependent on case law. Two things that we were pushing for, and one of them touches on SLAPPs. One is preventing private companies from bringing legal action, which was a big push of the campaign. Didn't go anywhere. I don't know whether it was seeming too Marxist or Leninist or something, but it didn't really go anywhere. Even a compromise position modelled on what Australia does, which is any private company above 10 employees cannot bring defamation action, which we thought would protect the small and medium-sized businesses but prevent abuse by the big corporations. That didn't go anywhere, so you can still private entities can still sue in Scotland. One of the other things was looking at existing laws on the books in the UK, and one of the really interesting pieces that we looked at was the intellectual property unjustified threats Act 2017, which is UK-wide legislation, which enables someone to bring a counteraction if someone's brought a vexatious allegation of violation of intellectual property. What we quite liked about it was it would empower people being threatened of action to bring counteraction even before it's made it to court. So it could engage with that, as Jill was talking about, the bigger chunk of the iceberg when things are being threatened and things like that. And that's a really interesting way of using existing UK legislation, but looking at it within the defamatory context. Again, there was not appetite for it. I think now, and I'll end up here, I think in Scotland, we are going to have a challenge. This bill is new. It has not really gained footing yet. And also in Scotland, we need to make the case that it's not just defamation. It's all these other things. There's always the pending question is, if legislation changes in England, will it migrate north to Scotland? It hasn't really happened to date, but if we have an anti-SLAPP mechanism for England and Wales, maybe it will. So I think Scotland needs to be alive to this, if only as a preventative measure to ensure that its legislation doesn't become home for these sort of cases that are frozen out of the England and Wales post, hopefully, the model law being brought forward. So I think there's lots of opportunities in Scotland, but it's going to be, I think, right now, I think defamation reform was pushing on an open door. Mm-hmm. I think the door here is going to be a lot more harder to shift on SLAPP, which is not to say we shouldn't do it. And I think we're just going to need to be very savvy as to how we position any form of anti-SLAPP reform in Scotland.
Great. Well, thanks very much, Nick. I think what's interesting coming through from what you've all been contributing so far is almost the similarities with between Northern Ireland and Scotland, a difference in scale and size, different cultural and political considerations which drive a lot of things. So it's not always the same. And also this idea of we are talking a lot about defamation, which hasn't been part of the conversation in terms of SLAPPs because it's just not that's been done, and we're talking about something completely different here. But I think it was interesting, and we'll maybe come back to some of this. And that's just wanted to say in terms of thinking about questions from the audience, please have your questions ready when we come to the end of our speakers. And similarly online, if you just want to put your questions in, we'll be able to come to those later. But yeah, interesting that you were able to pick up on some of what you thought was potentially best practice in Northern Ireland, which ironically didn't make it through in Northern Ireland. So let me just go to the person who was driving that legislation in Northern Ireland as a private member's bill. Mike Nesbitt joins us now. And Mike is, for those of you who don't know, a journalist by trade as well, and was a leading presenter on UTV back in the day. Mike, so you had I suppose the journalistic hat and a politician's hat when you brought this legislation. What did you manage to achieve then?
Well, first of all, Jim, sorry, apologies. I haven't been for the whole of the debate. I've been unable to get online on the desktop. Perhaps appropriately, given I'm at Parliament buildings, it's not working. But yeah, my interest began as a broadcast journalist with Ulster Television. I was involved in 3 defamation cases, perhaps coincidentally all involving the DUP. But the common theme was once the defamation process had begun, I found myself around the board table at Ulster Television with the production team, UTV senior managers, our legal advisors, and 2 others who had flown in from London, and they sat quietly in the corner and said nothing until we had our debate. And then they said, well, you know, we're your insurers, and your maximum cover is, say, £100,000, which was just a code for settle out of court. So I'm sure Sam has told you about the number of letters and phone calls he gets from lawyers of basically of a threatening nature. Because it's not about the number of times defamation cases end up in the courts in Northern Ireland. It's about the untold number of those calls and letters that go out in advance. And effectively, it's about who has the deepest pockets. And somebody mentioned Dr. Andrew Scott, who, of course, produced a paper on reform of defamation in Northern Ireland in 2016. And I'm going to make one quote from that report, paragraph 105. Which said the key imbalance is arguably not that in favour of reputation over free speech or vice versa. It's between litigants who can afford to defend their publications or to vindicate their reputations, and those who cannot. So when I was interested in bringing forward this bill, it was because when England and Wales reformed in 2013, it fell to our finance minister, a man called Sammy Wilson, now an MP, to decide what to do. And I think he had three options. He could have brought forward what's called a legislative consent motion, which basically would have extended the jurisdiction of the English and Welsh law into Northern Ireland. He could have gone out to consultation about other reforms to defamation, or he could have taken an option paper to his executive colleagues, and he chose neither. He effectively chose to make his own decision that we didn't need to reform our laws of defamation. And I thought that was strange, given everybody must recognise that the media has an enhanced role in scrutinising the work of government here in Northern Ireland. And I say that for two reasons. One is we don't have a second revising chamber, such as the House of Lords in London or the Seanad in Dáil Éireann in Dublin. And secondly, it's very rare for us to have an official opposition in our unicameral chamber. When there's been a functioning executive over the last 24 and a half years since the Belfast Agreement, there's been an official opposition for about 6 months. So I began that process back in 2013 of introducing a private members bill. And then the new finance minister, Simon Hamilton, he did a very clever thing. He commissioned the Northern Ireland Law Commission to conduct the review that turned into Dr. Andrew Scott's report. And it was clever because, you know, if you're being benign, he was looking for a way to overturn his predecessor's ruling. If you're being not so benign, it was just a way of kicking the can down the road. Dr. Scott published in June 2016, at a time when the Assembly was hurtling towards collapse and that 3-year hiatus. When we got back in 2020, I picked up my private members bill, but what I needed was the consent of the Secretary of State to legislate on the clause I wanted to put in on the internet, because telecommunications is a reserved matter. Ironically, it took a long time to get that, and the effect was simply to delay the bill, because when it came to the vote, the DUP and Sinn Féin both voted down the clauses on defamation on the internet. So I was further frustrated by the last Minister for Finance. The role had swapped to Sinn Féin and to Conor Murphy, and I think for political reasons, understandable political reasons. He wanted to wait to see what was happening in the other jurisdiction on the island, because the government of Ireland was looking at reform of defamation, but he didn't have the power to block me. So I went ahead and introduced my private members bill, which is now an act. I did lose 2 clauses. I've mentioned the one on the internet. I also lost the clause on serious harm, but I got the one on public interest, which I don't think many of the members of the Legislative Assembly realised just how significant that was. And in conclusion, because we're actually talking about SLAPPs, this came up. It wasn't a thing, as it were, when I started back in 2013, but it has become a thing since then. And I got a written guarantee from the Minister and from senior officials in the Department of Finance that they would not only continue to review the implementation of my act, but that they would look at the implications of SLAPP for freedom of speech. So although I have an act and we have reformed the laws of defamation, I haven't finished, and I hope the Assembly hasn't finished in looking at the chilling effect of defamation and SLAPPs on freedom of speech in this jurisdiction.
Mike, thanks very much for that. Yeah, I think the key thing that you identified from Andrew Scott's report was the idea of cost, which of course brings us into one of the kind of key characteristics of SLAPPs, where it's not about the rights and wrongs of the case, it's just about punishing your opponent. So let's sort of see if we can get into some of the SLAPPs issues as well. And anybody got any questions at this stage for our panel? We'll be able to bring the microphone to you, so please don't be shy. And we'll keep an eye on those questions online. I should just say, you know, from my own experience, I've joined Open Democracy where I've left. The BBC obviously has is a much bigger organisation. I would have dealt with legal quite a lot because of the nature of the stories that I did. But Open Democracy has its own SLAPP's case. It was mentioned earlier on. Tom Burgess mentioned it. And we also have an insurance excess, which means that we potentially have to stump up 30,000 on any case. So, I mean, that's a hefty bill before anything else is paid for, before you could even call on your insurance company. So these are the issues for the small organisations. What do you think can be done to persuade politicians in Scotland, Rosalind, that this is an issue that they need to address so that, as Nick says, it doesn't become the jurisdiction of choice for those fighting these kind of cases if there is reform in England and Wales?
Well, one of the things that stays with me from when we were in the mire of trying to get the Defamation Act through, it's a very journalistic thing. What you need are faces. You need individual stories, and we were we look back now, we were really lucky to get that through. The stars aligned, even though it took a very long time for them to align, because we had, just as it happened at the Scottish Law Commission, there was one of the very few silks in the Scottish Bar who did know and was interested in defamation law. He was able to give examples from his own experience. We had Andy Whiteman, who was a member of the Scottish Parliament, who had written on a topic of tremendous sober public interest, which is about land titles in Scotland and the sale of them, and he was facing this ridiculous telephone number claim. So that was quite persuasive that they could see, and probably also when it came to the point, which was quite a way down the track, where the parliamentarians were deciding on to pass this, it was one of their own, and actually another of their own, Kezia Dugdale, the former leader of the Scottish Labour Party, had also been sued for defamation. So, as I say, I couldn't have controlled that. We couldn't have put that in place. But as it happened, those stories were quite powerful stories, I think, and they gave a bit of traction. There was also, again, just an ordinary Joe, a lovely man who worked in pain relief in a little village called Straven, which is famous for nothing but making toffee, who edited the local chat forum and ended up getting sued. Cases like that, people need to understand why this is a problem, and they also probably, the parliamentarians, need to understand that it's like water finding its level, in the same way that if the cases had timed out in London, they could very easily have come north to Edinburgh. And whether that's a good thing or a bad thing, I guess, depends on whether you'd be getting paid for that.
But obviously, some of the lawyers, as Nick was saying, seem to think that was a good thing. It was a money-making exercise.
Well, yeah, I know. By which token, probably should arrange a bit more murders so that the criminals could. Anyway, yeah, as I say, it's all right for me to say that, doing what I do, but that kind of scenario, to realise that if you want your Russian oligarchs to stay away from your own shores, you need to make sure that you don't make a welcoming environment. So I think probably a bit of a greater awareness about PR, a greater sophistication. I see now quite frightening things coming out. Like a law firm, who shall be nameless, sent out a round robin recently to its clients, saying how to know if your client is the target of a smear campaign. And the reasons that they gave for how you would know if your client was a target of the smear campaign are exactly the same ones I know if your client is a proper target of investigative journalism. So
is that sort of merging of the law and PR and reputation management? Yeah, I mean, I suppose that the key point there, and you mentioned it just at the end, the context which has driven things forward here, pushed it up the agenda. Obviously, many people here have been working on it for a lot longer, but the context is the war in Ukraine.
Yeah.
And, just bringing, say, Sam, if you were able to jump back in on this one in Northern Ireland, you mentioned your own experience. You mentioned various writs from DUP politicians, and probably be fair to say that you're not particularly popular with politicians of other parties as well. So perhaps your story isn't going to convince them to move on SLAPPs. What do you think would? Not that we have
I think that
there's no functioning executive at the moment, but assuming you could get something done in the meantime or at some point.
Yes, would that we had a government that we could try to convince about any of these things right now. I think that one aspect of this, which sounds maybe not entirely dissimilar to some of the experience in Scotland there, is that politicians have started to find themselves on the receiving end of these claims themselves. They are now publishers in their own right on social media. Increasingly, they're publishers in other forums as well. And so there have been 2 cases in Northern Ireland in the last decade or so where Sinn Féin have lost major libel cases that have cost them hundreds of thousands of pounds. And that is the sort of thing where I think it starts to get through to these people that maybe there is another side to this. Maybe, yes, we don't like this story or this individual, but we could find ourselves on the wrong end of this, because there's a lot of people who don't like politicians, a lot of quite cruel stuff that's said about politicians, as we know on social media, very unpleasant stuff, and people who, if they could try to abuse the law to get after them, would use that. I think also there is an onus on us in the media to be more forthright about what's going on here. That's something which you've been very good at Open Democracy, Jim. Peter Geoghegan's been very good about that. There have been certain outlets that if you come after them in a spurious way, they will turn that into a story and they will inform their readers about what is happening. And I think far too often, in my experience, there are either editors or lawyers who don't want this to be reported. They want it to be kept secret, and that's dangerous. And it's not just dangerous because the public don't know what's happening. I mean, I've spoken to lawyers involved in media law in this jurisdiction and elsewhere, and they genuinely, I think, when you speak to them privately, think that the media is this extraordinary behemoth that it was maybe 20 or 30 years ago. They don't realize how incredibly tiny some of our budgets are in regional press in particular, and so they think this is just fishing in a pool of gold, that it's no big deal. We've got deep pockets, our owners have deep pockets, it will be fine. And alongside that, a sense that there is just rampant bad behavior in the media, that the sort of phone hacking, news of the world stuff, that's the sort of people they're dealing with. So I think there is a case for us to educate people, and I'm not trying to suggest that all of these people are in any way uneducated, but I think there is genuine ignorance around aspects of this, and to be very forthright about this is what we're facing. And if Joe Bloggs, who's a prominent politician, can stand over this, fine. If he can't, he should be embarrassed that he's taking this case against us.
Good point. Sam, well, funny enough, just in chatting to some politicians recently, I've discovered, they're also being sued by other politicians. So that's an interesting subset of some of this. But just on that point about going public, obviously Open Democracy, and we've mentioned already the Nazarbayev case, which we have gone public with, and the Bureau of Investigative Journalism and others have highlighted that case. I understand, actually, and it was Susan who told me that on a previous occasion when Open Democracy went public about a libel action, that their insurance premiums went up. On the other issue in relation to how we deal with some of this, I have a case recently, but my job is to report on SLAPPs. And that by its nature just presents its own problems. And so actually in a series of right of replies I sent to some of the law firms that have been mentioned in Parliament, and that's probably the only way that we can identify firms as associated with SLAPPs type behaviour. I got a letter back which was exactly the model that we were discussing earlier on, not for publication, private and confidential. So you ask a series of specific questions based on parliamentary privileged material that has already been aired in public, and instead you get a kind of letter back which sort of implies a legal threat. So yeah, it's all very well to say let's be brave, let's publish and be damned, but none of us really want to be damned if that means losing our jobs or the organisation itself going under. So what do we do?
I think some of it goes back to what Sam was saying, the sort of the public awareness of like the importance of an independent, vigorous, well-funded public watchdog sphere. So whether that's journalists or whistleblowers or NGOs, and like a threat attack on them is also attack on the fabric that makes like a participatory democracy possible. I mean, one of the saddest things I remember when the Andy Whiteman case was sort of went public, and he was very explicit about wanting this to be a case that demonstrates the need for reform in Scotland. It was like when he went public, and when we helped sort of amplify that, there were not I don't remember seeing any statements of support from other MSPs made publicly. Maybe they supported him, as colleagues behind closed doors, but there wasn't that outpouring of support from his colleagues saying this is a risk, this is a threat, this is preventing our ability to be able to. Because you need politicians to be able to respond to challenging issues. Is why you have privilege the way that you have it. So bringing something back from his previous life as an academic into that MSP space, really does chill that sort of engage. You want that engaged MSP, but then the fact that none other MSP came forward, I think was a real problem. And I think also there is that conversation about making sure that outlets are supported when they do want to go public. Because obviously, yes, there's no legal contract when you get whether there's a conversation as to whether it will increase the level of harm being caused to the claimant. Maybe that's a more challenging aspect of that. But you wouldn't do that if you know that there isn't really the public support to back you up. You wouldn't take that risk. You want to take that risk when you know people have got your back. I think there needs to be that building of that sort of conversation. But also, it is also the reality that we're having a shrinking media space like everywhere else in the UK. So, I mean, BBC Scotland is mercifully at the moment funded enough. Well, I mean, but it is there. But then, the big Scottish newspapers are shrinking. And the first thing that goes is in-house legal or access to high-quality external legal support. And then, you have a lot of smaller publications, a lot of independent publications. A lot of them came out after the independence referendum. Some of them have closed their doors because of many reasons, but I think a lot of it is also how viable it is at the moment. And so you then get, if you don't have legal support, it's not viable and it's too much of a risk. But the thing in Scotland, which is wild, is that you can still get legal aid for defending defamation actions, technically. But I've never heard of anyone actually succeeding in doing so. And I don't think that's the case in England and Wales. And it's a good thing, but it needs to be accessible. And there is a broader conversation, like even in England and Wales, Ministry of Justice is not keen to talk about legal aid because obviously that's a far bigger topic. But I think in a lot of this, and in Scotland as well, and I imagine maybe in Northern Ireland, it is the ghost of the feast, because then it ensures people can at least guarantee, at least depend, they know that there's some funding there they can depend on if they want to mount a robust defence. I think, just one thing is like the Straven case, I think is a really interesting case to see where this sort of situation goes, because when you have the retreat of local journalists or local outlets, communities will go on Facebook, and most of the moderation is done voluntarily by people who are not experts, but they still engage with really powerful people. The Straven case, it was a multi-million-pound business housing developer who was going after
the Quadras.
Against Paolo, and Paolo was doing this in the snippets of time around his day job, which had nothing to do with law. And even when he came to had to defend himself, all he could depend on was his local solicitor, who had no media. And this is obviously not to denigrate them, but they're a local solicitor. Defamation is not something that would come across their desk very often. Mm-hmm. Whereas the defender was able to the claimant was able to depend on one of the biggest law firms in Edinburgh. And I think these are the sort of cases that we need to look at. When the media landscape evolves, slappers they are very fast to respond to this. They're very quick to see where the weak links are.
Yeah, and these are the individuals that we know of. We don't know how many that we don't know of. Let me bring a question in from the audience. Yes, just down at the back here, but just bring the microphone over to you. Thanks.
Right. Yes, Craig Oliphant from the Foreign Policy Centre, and I'd like to thank all of the panel for the really interesting overview. I had a question really for Sam and Mike in terms of your perspective on the situational approach in Dublin towards these issues, and whether there were any push-pull effects really from the legislative, the judiciary approaches there that could have impacts. Thanks.
I'll bring Sam in on that, partly because Mike, unfortunately, for technical reasons, won't be rejoining us. But also Sam's part of a group. He's the Northern editor, also of the Sunday Independent. But it's a group that operates with big titles in the south of Ireland as well. Sam, so have you any sense of that in terms of any movement in the Republic and how that might impact things in Northern Ireland or in the rest of the UK?
So I've got limited limited insight here, because happily I've never, I don't think, been sued by anyone from the Irish Republic, even for what I've written for the Sunday Independent. One of the major issues in the south of Ireland has been the size of huge compensation claims which have been given by juries, etc. That's a particular problem there that we don't have it in Northern Ireland. So they've got the double issue of massive compensation claims potentially and guaranteed enormous legal bills. We fortunately, for one reason or another, only have one of those issues, and it's enough to contend with. But I think that certainly from Sinn Féin's perspective, as one of the two dominant parties here, they on a broad level want to harmonise as much of the law as possible across the Irish border. And so they were, as Mike Nesbitt said, trying to actually stop his bill completely. What he didn't say was that Conor Murphy, the finance minister, who has got the power over this area of law, was really quite robustly trying to stop him getting this law through at all. And we have seen a lot of significant claims by Sinn Féin, a massive upsurge in claims over the last couple of years on both sides of the Irish border, but particularly in the south. Mary Lou McDonald has been designated as someone who is taking a SLAPP case against RTE. They are defending that, it seems, and it's good that they're defending that. But there, I think, is an aspect here where the DUP led in Northern Ireland, and there's a lot of publicity around that. And now Sinn Féin are following that. They're spying an opportunity, and they're extending it into a broader jurisdictional reach than even the DUP had tried to do.
So there's this. Yeah, sorry, Nick, you want to come in?
I just think the Republic of Ireland, Northern Ireland, and the island of Ireland is an interesting conversation, especially in terms of harmonisation. Whether there can be a harmonisation with Northern Ireland with England and Wales, or whether there will be, because obviously Republic of Ireland with the EU anti-SLAPP directive, there will be conversations in Dublin about how Ireland works the EU directive. So I think there's a really interesting tension there. But also, Republic of Ireland's a really interesting case in seeing the sort of the type of defamation threats or SLAPP threats. Because in England and Wales, a lot of it will be corruption, illicit funds, because the UK is this nexus point for capital. Whereas, from journalists we've spoken to in Ireland, a lot of it is sort of environmental cases. You're seeing a lot of threats around sort of due diligence around environmental protections, and big companies in terms of how their impact on the environment, and then responding to journalists or NGOs or outlets. So I think how the landscape that underpins SLAPPs will be a very interesting thing. And also, yes, north and south, you do have parties like Sinn Féin who are themselves bringing action, and also against a public broadcaster, which obviously Rosalind knows only too well how that manifests in the BBC, and that's something we need to be alert to, because that dynamic. Parliamentarians bringing action. I don't know of anyone in Scotland in terms of defamation, them bringing an action in the same manner. So
no, it's not. Somebody had reported that Joanna Cherry was going to take a legal action, and she instantly issued a rebuttal saying, "No, I'm going to take a regulatory complaint." So it's not done in Scotland.
Yeah. Well, that does seem to be a bit of a difference then in Northern Ireland and in the Republic, where politicians are actively involved in taking cases, or at least threatening to take them. Here's a question. It's actually, again, directed. It's from Tim Carson coming in online, and it's directed to Mike Nesbitt. But unfortunately, as I say, Mike isn't here. But I want to maybe just put it to our panelists here, because what Tim's asking is, do you consider that tackling SLAPPs in Northern Ireland will ultimately require reconsideration of a serious harm threshold for defamation claims? So maybe regardless of the SLAPPs aspect to it, do you think that that's a big failing in the Northern Ireland bill, that they didn't manage to get the serious harm bit in?
Yes, a great missed opportunity. When you look at what's been happening, for example, in Canada recently this year, Rebel News Network one with an anti-SLAPP argument in Vancouver, which essentially probably you would have done here through serious harm, I think, rather than that. And if you don't have that, it's difficult to. It's a big miss.
Yeah. I mean, it's a pity I can't ask Mike as to why he thinks it was knocked down. What any speculation on that one, Nick?
I can't speculate, but I agree. I mean, that was one of the big was one of our big top line sort of when we were working on the campaign. Is like, what developments, what calls do we have that we know we may lose, and it's not the end of the world. Whereas like serious harm, I find it hard to have any framework for an anti-SLAPP conversation without things like serious harm and without that, and also it's now getting tested in English courts, which is it is definitely getting bedded down as well. And I think that will increasingly, there will be increasingly a bigger divergence between legal jurisdictions if that's not.
So I mean, just you mentioned about the possibility of if you like, it's like water finding the path of least resistance. So will the legal cases then start popping up in Northern Ireland? If there isn't a sort of equalisation of the law in some shape or form, because similar media, broadcasters, you could take cases there if there's a weakness there.
I think they could do. I mean, there's always. I mean, Northern Ireland and Scotland. There's always this ongoing conversation as where will cases go if England and Wales shores itself up, and we didn't see an uptick in Scotland after 2013. Not to say we won't if there is an anti-SLAPP law brought in England and Wales. It's hard to know. But also looking at it, I mean, one of the cases I really like was the threat against Sky by I think the Scientologists. Or lawyers, now I'm avoid I've mentioned Scientology, but they were going after the broadcast because they knew that the channel itself couldn't differentiate the signal. So if it couldn't be screened in Northern Ireland where they brought the action, it wouldn't be able to be screened anywhere in the UK because Sky couldn't sort of block out Northern Ireland and that's a really interesting. I mean, to be fair, incredibly tactically astute piece of litigation is looking at one jurisdiction, potentially a jurisdiction they think they may have a greater chance of success, knowing that the impact is far beyond that alone. So I think we do always need to look at the interplay between jurisdictions. I don't know whether people will go to that, but I mean, I've heard people say that Belfast and Dublin are already increasing in terms of their interest as a jurisdiction. So, I think if that is the case, they would only be heightened if England tightens up its anti-SLAPP mechanism.
Sam, any thoughts on that? Will Northern Ireland become a hotbed of more litigation if England and Wales are tightened up on SLAPPs?
So after the 2013 Act, there was a serious fear around this, that Northern Ireland would be the weak link in the chain, and particularly if you think about a national newspaper like the Times, the Daily Telegraph, or the Guardian, it's not feasible for them to have two sets of lawyers reading their copy with two different jurisdictional aspects in mind for a tiny market in Northern Ireland where they maybe only sell a few thousand copies. And the fear was that we would simply lose lots of these national news outlets. That hasn't happened, and I don't think from the evidence to the Stormont Assembly Committee that was looking into this during the passage of Mike Nesbitt's bill, I don't think there's any evidence that there has been that libel tourism. I think, though, we should be cautious about drawing too many inferences from that, because it may just be that lawyers aren't aware of this, that they haven't realised it. The danger about talking about these things, unfortunately, is that you draw people's attention to it. And so, as Nick says there, what happened with Scientology and Sky, where they used Northern Ireland tactically, was a very obvious thing to do. It surprises me that it hasn't happened in other areas, and it's a massive problem with Mike Nesbitt's bill. It's not his fault, it's the fault of the DUP and Sinn Féin, but it's a massive problem that serious harm was lopped out of that. And during my evidence to the Stormont Committee, I tried to say to them, look, it's not right to tell lies. It's wrong to tell lies. If you think about it in these terms, it's morally wrong. It's something which is unprofessional for me as a journalist. It's contrary to the contract that I sign, etc., etc. But should we make lying something which you can take somebody to court over in a general sense? Well, no, of course not. Most people would say that's an issue which can be dealt with through other forums. And I found that there was really a total lack of comprehension of this point. Some of the MLAs turned this round on me and said I was advocating lying. Some of them said that, well, so what you're wanting here is that you can harm me a bit, but you don't want to harm me in a serious way. And there was just a failure to engage with the significance of these points. So it's a massive problem with it, but it's still good that we've got some of the other aspects of that bill on the statute book now.
Thanks very much, Sam. Yep. Well, anybody want any last questions before we wrap up the session? I think it's lunch is beckoning. So just a big thank you to our panelists. Thanks very much to Roz and to Nick joining us here in person. Thanks, Sam, for joining us from Belfast, and to Mike, whom we heard from earlier. So I think it's time to break for lunch. Back again at 2:15. Thank you all very much indeed.